Hi, I'm Dan Frith. I'm a senior partner here at Frith & Elliman Law Firm in Roanoke, Virginia. If you received a link to this video, it is likely because one of the attorneys in this office have declined to investigate your potential medical malpractice case due to inadequate or insufficient damages. This doesn't mean that you received good medical care. It doesn't even mean that you received adequate medical care. It means something entirely different, and that's why I'm making this video to explain what goes into these decisions on our part. We tell our clients all the time, you do not want to have a good medical malpractice case. Why? If you do, someone has lost their life. If you do, someone has lost an arm, a leg, or the use of their hand. If you do, you spent 2 or 3 weeks in the hospital, maybe 2 or 3 months in the hospital for something that should have been a 1 or 2 day stay for a simple procedure. It may mean that you suffered a brain injury, or that your loved one has suffered a brain injury and can no longer function at the level that they once did. So what are the considerations, what are the financial considerations that we have to factor in trying to decide whether to recommend full investigation of your situation? Medical malpractice cases are different than automobile accident skid mark cases. Medical malpractice cases are different than slip and fall cases. They're much more expensive, probably on average 10 to 20 times more expensive than those other general routine tort cases. Why? Well, I want to explain that. First thing we do is we request all your medical records, probably for the last 10 or 15 years. That doesn't cost a lot, $200, maybe $300. Next, we review all those records in detail, conduct our own research of the medical literature relevant to your situation, and discuss with you what we're finding and what we're seeing. At that point, if we determine that this case is worthy of the next step, we have to go find an expert to review your records. If you're upset with the care provided to you by an orthopedic surgeon, we have to find an orthopedic surgeon to review your records. An orthopedic surgeon who does the same surgical procedure that's involved in your case. Same goes for vascular surgeons, neurosurgeons, hematologists, pathologists, radiologists. About any specialty you can think of, we have to compare apples and apples, and we have to go find a doctor trained in that specialty to review your records. That doesn't come cheap. Most of those experts will charge anywhere from $2,000 to $3,500 to review your records and provide us with an honest opinion on whether medical negligence occurred to you and whether that medical negligence caused you harm. What comes next in the terms of expenses? Depositions. Once the lawsuit's filed, and that doesn't cost a whole lot, $200 or $300, but once the lawsuit's filed, depositions take place. Those depositions of you, your family members, any other fact witnesses, the defendant doctor or surgeon or nurse or hospital personnel or nursing home, those depositions run typically on average $750 to $1,500 each. And you can see that adds up pretty quickly. Last and foremost is medical liens. If you're insured or have health insurance through Anthem, Blue Cross Blue Shield, Cigna, or a dozen or 100 other medical insurance providers, they may have a lien on any recovery you make by way of settlement or jury verdict against a responsible healthcare physician. So you could litigate a case for a year and a half, receive a recovery, and Anthem puts its hand out and says, thank you so much, please pay us back the $30,000 we had to pay for treatment that was required because of the medical negligence against another physician, and you made a recovery. Now, even if you don't have private health insurance and private health insurance that has a lien, you may be 65 or older and be a Medicare beneficiary. Medicare has a lien. They'll usually negotiate with you at the end and pay a pro rata share of expenses and costs, but you still have to deal with Medicare at the end, and you're going to have to reimburse them for something if they paid for your subsequent care. Same thing with Medicaid. If you meet certain financial criteria under state and federal law, you may be a Medicaid beneficiary. If you are, and Medicaid pays for some of that subsequent treatment, they're going to have a lien. And they're a penny for penny lien requirement. If they paid $100 to a doctor to treat you because of problems suffered as a result of malpractice of another doctor, at the end of the case, if you're successful, you're going to have to pay them that $100 back. So these are all the reasons that we tell people when we think all of it through based on our years of experience. We don't recommend pursuit of a malpractice case. We don't think you have sufficient damages or injuries to make it worth your while. I hope this short video has helped explain these considerations. We don't like telling people that we don't recommend investigating their case. We would like to investigate everyone's case, but it doesn't make sense for some people. We appreciate you contacting our firm. Thank you.